my name is Shivam Mishra and I am advocate practice law Uttar Pradesh. Today I am going to discuss one of the most important concepts in the criminal justice system, that is called the bail. About the bail, I can just only say that if you are going to make a career in the criminal litigation, then you must aware about that fact that your the career graph, your the growth is directly proportional how quickly you got a bail in your favor from the court of law. So in this video lecture we will discuss some of the case law you can use for getting the bail in your favor in the court of law. You need to become very prepared, you need to become very alert. Why? Because there is always public prosecutor who is ready with the saying that श्रीमान जी महोदय ऑफेंस जो अपराध हुआ है बहुत गंभीर किस्म का है, इसलिए बेल नहीं दिया जाए। इस पर्सन को बेल देने पर ये पर्सन, इससे समाज में एक गलत मैसेज जाएगा। इस पर्सन को बेल पे ना दिया जाए क्योंकि इसके पास एक बहुत बड़ी क्रिमिनल हिस्ट्री है, एक क्रिमिनल हिस्ट्री इसके पास है। दैट इज सम ऑफ द ग्राउंड दैट पब्लिक प्रोसिक्यूटर इज always oppose the bail, so you need to become alert. So when the public prosecutor is saying that महोदय बेल ना दिया जाए क्योंकि अपराध बहुत गंभीर किस्म का है, at that time you use the judgment of the P. Chidambaram versus Directorate of Enforcement, and that is also known as the INEX media cases, where the E.S. Bopanna, Justice E.S. Bopanna and Justice R. Bhanumati, that clearly says that was decided in the 5 September 2019, and you can make at the argument stage you can use the judgment of the INEX media cases that gravity of the offence can be consideration for the deciding the bail, but that cannot be only ground for denying the bail. So this judgment you can use. And another very useful judgment from the gravity of the offence you can use, that is I think that is a Sanjay Chandra. Yes, that's a very landmark judgment, Sanjay Chandra versus CBI, that was decided of the 23 I think September, that was the month of the September, 23 September 2021. That's a very recent judgment where the Supreme Court, where the bench of the Justice G.S. Singhvi and Justice H.L. Datto, where the Supreme Court clearly says that gravity may be one of the consideration but not solely. So you use both of the judgment at the time when the public prosecutor opposing your bail by saying that gravity of the offence. So this both cases you can use for at the argument stage of your bail. That's the first case, that is known as the INEX media cases, and second cases, that is Sanjay Chandra versus CBI, that is the cases that is well known as the 2G cases also. So these cases you can be used when the public prosecutor is saying that gravity of the offences. So gravity of the offences, this is a case law you can use at the time of argue on the bail stage. The second ground that generally public prosecutor takes, that if we grant him bail then it will be wrongful message to the society. अगर हमने इनको महोदय बेल दे दिया तो ये समाज के लिए गलत मैसेज जाएगा, and that time you just use the Delhi High Court one judgment in the Firoz Khan versus State NCT of the Delhi. I think that is decided 29 of the May 2020. That's a very recent judgment where the High Court, where the Delhi High Court judge clearly say that court are not there to send messages. Court are here to decide bail with the settled principle. So you can use this judgment when the public prosecutor is saying that wrongful message will go in the case of giving the bail. So these judgments you can be used while you are arguing on the matter of bail. And sometimes the public prosecutor says, and sometimes what say it is always I will see that public prosecutor says that accused person have long criminal history. At that time you can use the judgment of the Prabhakar Tiwari versus State of UP, and that is decided 24 January 2020. That is a very landmark judgment, and that is a very recent judgment is also that where the Justice Deepak Gupta and Justice Anuj Bose, and that clearly says that criminal history factor by themselves cannot be basis for refusal of prayer of bail. Refusal of prayer for bail. Again I am repeating, in this judgment where the criminal history Prabhakar Tiwari versus State of UP 24 January 2020, where the Deepak Gupta, Justice Deepak Gupta and Justice Anuj Bose, this bench has clearly says that criminal history factor by themselves cannot be the basis for refusal of prayer for bail. So this judgment you can use while the public prosecutor oppose your the bail application. So you need to become very alert. Why I am saying, in our criminal justice system, the principles, that is always the presumption of innocence is always there. And one of the one of the judgment in year 1977, and that thing I think state of Rajasthan versus Balchand 1977, please make me correct if I'm wrong, but where the Supreme Court observed that put as bail not jail. Bail is a rule and jail is an exception, you can be say in your for your understand purpose. In the judgment that is a 1977 state of Rajasthan versus Balchand. So so this is the things you can use while you are arguing on the matter of the bail. And one of the landmark judgment of the on the case of the bail, where the Supreme Court in the case of I think state of Uttar Pradesh versus Amarmani Tripathi year 2005, where the Supreme Court makes some parameter while deciding the matter of the bail. The court must observe on the certain point. I am giving the some of the observation that court must take while deciding the bail. That is decided by the state of UP versus Amarmani Tripathi year 2005 Supreme Court decided the parameter. I am giving the list. I am giving the some of the parameter. That's some of the parameter like whether there is any prima facie or reasonable ground to believe that the accused has committed the offence. That is the one of the parameter while the deciding the court must consider. And the nature and gravity of the offences, that can be another parameter. And the severity of punishment in the case of conviction, that is also a parameter while court is deciding the bail. And the danger of the accused absconding or fleeing if released on the bail. So this is a parameter that can court observe while granting the bail, while discussing on the bail, while the arguing on the matter of the bail, while deciding the bail matter. And there is a character, behavior, means, position and standing of the accused person. That is also one of the ground while court can consider while deciding on the bail. Likelihood of the offence being repeated, that is also, this may be one of the ground, one of the measurement, one of the parameter. Reasonable apprehension of witnesses being tempered, this is also one of the parameter and ground. So these are the some of the parameters Supreme Court in the judgment of state of UP versus Amarmani Tripathi year 2005 laid down. So this thing you must also consider in your mind when you are arguing on the matter of the bail. And some things sometimes in the case of the PASCO cases, in the case of the SC/ST cases, where the court, it is a statute, it is a legislature, it is a rule is there that while deciding the bail, court must first listen to the complainant also. This is in the case of SC/ST cases, in the case of PASCO matter. So in these two cases, or many other some other provisions also, where it is a mandatory for court to listen the complainant for deciding the bail. In the SC/ST, again I am repeating, SC/ST and the PASCO cases as I earlier discussed. So in these cases you must understand the fact that in our Article 21 of the Constitution, life of personal liberty and right to speedy trial is a fundamental right. And that time you can make a request for the court for grant the interim bail. For that purpose you can use some of the landmark judgment, that is the Amravati and others versus state of UP, that is the 2004. Again I am repeating, for the antarim zamanat you can is the interim bail, you can use this judgment Amravati and others versus state of UP 2004. And another judgment that is very useful, that is the Lal Kamlendra Pratap Singh versus state of UP year 2009, which these judgments you can use in the case as I earlier discussed, in the case of the PASCO matter, in the case of the SC/ST message, where the court must listen to the complaint before deciding the bail. So in these situations you can make a argument for getting the interim bail. So these are the judgments, these are the arguments, these are the preparation you must make while you are arguing on the matter of the bail. And sometimes again I am saying bail, why bail is a very crucial stage, because in a criminal justice system the trial is a very long journey. So bail is the stage where you can be bail is the stage where you can be get a relief for your client in a very early stage. So you need to become master, you need to become very you need to become master, and you need to become very alert.